So there's a bunch of ways to try to minimize the duration of a probate. There are some front end things, and what I mean by that is that if you are alive and having some concerns about what your will is going to look like. And what I mean by that is, if you have a child that you want to disinherit, you haven't talked to them in forever, or you have a child that has substance abuse problems. Let's stop this for a second. So on the front end, I think that's one of the ways that we can minimize it is by trying to make sure that your will is going to address all of these potential problems. So if you have a child that you want to disinherit, if there's a fear that somebody could try to overturn the will by claiming that you were mentally incompetent or that you suffered, undue influence, that somebody kind of forced you to do it, there are things that we can do in that will process to minimize the potential litigation threat, once somebody passes away. The fact that we set up, we have provisions oftentimes in our will called an terrorem clause. And basically what that says is that if anybody contests the will by trying to claim that my client was either mentally incompetent or that somehow somebody unduly influenced them, we can actually put an terrorem clause in there that person that contests the will for some ridiculous reason actually gets kicked out of the will. So I think part of the way to minimize the probate process is to put really good structures in place before you ever pass away. Then, once somebody passes away, how do we minimize it? The best thing I can tell you there is the more organized our clients are, the more responsive they are, the quicker it's going to go. We've had some clients that literally at the first meeting brought us every bit of information we asked for. Bank statements, titles to the real estate and the cars, complete listing of all the assets, who the heirs are, all of that stuff. And if we don't have to go get formal appraisals done, there's been some successions that we've been able to literally settle within a month, with just 2 meetings. Now granted, that's, a lot of times, everybody's different. I can't tell you how many times, a client comes in and says, well, we need to do the succession. It's going to be so simple. And invariably, there's always going to be at least one major kind of curveball that comes up. And it can be any number of things. We just had a client recently that he was pretty certain that his father had left the kids as beneficiaries of his retirement account, and unfortunately he had not. He had actually listed his former spouse as a beneficiary. And it's things like that where the client will come in and say, this is going to be simple, because in the client's mind it should be. And it rarely is that simple. So, but again, the good thing is that by going to somebody that has done so much of this type of work, it's going to be more likely that the estate not only gets handled properly, but it gets handled very quickly. Whereas when you go to somebody that, has done some successions, they've done some personal injury, they've done some family law, they don't know what they're doing. A lot of times, they have a little bit of experience in it, but they're not going to have the depth of experience. It's almost like if, again, I keep using the same example, but if I went to a cardiac surgeon and it was the first time he had just graduated from medical school, let's say, he's not going to have that experience that a cardiac surgeon that's been doing this for 20 years is going to have, and that experience can make all the difference in the world. And some people would say, oh, well, it's not as serious as a cardiac surgery. Well, I think it is. When you're talking about, again, these documents and this process representing everything you've worked your whole life for, you want to make sure that your kids are protected, that your spouse is protected, that all these threats are that we protect against all those threats, that it's handled properly. I think the whole idea of a fixed fee is in our client's best interest, because now you know exactly what it's going to cost you to do it. All of those things, we literally start with what is in our client's best interest, and then we work our way back. And that's how we've practiced law for 20 years. I tell people all the time, if I was in your shoes, knowing what I know as a board-certified expert in estate planning, what would I do? And that is what governs our advice to our clients.